I'm not his lawyer for now, and he doesn't have any lawyer for now. So how can he file an appeal before the Court of Appeal in Abuja that has exclusive jurisdiction over this case? How can he prosecute this appeal from 700 kilometers away in Sokoto himself? For now, Nnamdi Kanu is convinced that he does not need a lawyer.
Do you think that judgment has affected people's confidence in the judiciary? And how would you describe what really transpired on that day of the judgment?
Well, even before the judgment, we have seen large segments of the populations of this country tending to lose faith in the judiciary. We have to believe in our institutions. As a nation, we have to believe in the constituted authorities. If we don't have faith in the institutions, then we might as well forget about building a nation. But this conviction, this very conviction of Nnamdi Kanu, and the sentence itself being so cruel and unusual, I think affected the judiciary in much negative and adverse way than any judgment or verdict that has come out of Nigerian judiciary in recent times. And when people say that they have lost faith in the judiciary due to one thing or one conviction or one judgment or the other, and they cite this one as an example, you have to exhibit an understanding of where they are coming from. I think they are saying that the judiciary itself is not even infallible. Even the Pope himself is not infallible. The judiciary can be hoodwinked by an attritional prosecution that may tilt the scale of justice in the wrong way. We have seen some questionable convictions or questionable verdicts. Nnamdi Kanu's own is not the first. If we pedal back to the 1960s, Chief Obafemi Awolowo of blessed memory, was convicted of treason. You convict a man of treason, a man that bore no arms, a civilian. He was convicted in the 60s of treason and imprisoned. And a lot of people also had expressed loss of faith in the judiciary stemming from that very conviction. And that conviction convulsed the system. It convulsed Nigeria all the way to 1966, when it contributed to catalyzing the first coup that we had in this country. So society has to be very careful and circumspect in handling trials of this nature that have tendencies of having a more of political colorations than judicial colorations or legal colorations. I made it clear from the very beginning, in 2021, when Nnamdi Kanu was renditioned, that the rendition itself demonstrated stark evidence of a high political interest in his case. And that was why, when I was lead counsel between February 2024 and February 2025, I took very strong, muscular steps to make sure that that trial did not happen unless certain issues were resolved. The first issue was the issue of his bail. The Supreme Court has criticized the revocation of his bail, and in fact, the Supreme Court went as far as stating that the revocation of Nnamdi Kanu's bail evidenced some partiality or raised questions about the impartiality of the judge who revoked the bail. So, pivoting on that, I wanted his bail to be restored as the first test of the impartiality of the judge, as the first test of the justice of the case, as the first demonstration of fair play by the court. It was a test, but the court refused, and that put some fear in me as to whether the institutional deck had been stacked against Nnamdi Kanu. The second one was my objections to his trial. As a lead counsel, I had objected to the authority of the court to try him. That the Supreme Court sent back his case to the High Court did not give a whole-scale authority or jurisdiction to the High Court to subject him to trial without objection. There were issues in his case that needed to be resolved first before he put him on trial. Issue of jurisdiction. had to be resolved. So when it was denied, I went to Court of Appeal. So the case was pending on Court of Appeal, before the Court of Appeal, before we were debriefed by him, and Chief Kanu was brought in, and that was how the trial commenced.
All right. From your own perspective, just like many other Nigerians, how did you see that particular judgment? Because a lot of persons felt, well, there were too many things underneath it.
Well, the judgment was without consideration of the objections he had raised. He may have been submerged in popular media, but you will recall that Nnamdi Kanu had filed a preliminary objection to the jurisdiction of that court to subject him to trial based on repealed law. A lot of people don't understand the details regarding this repealed law. When Nnamdi Kanu was talking about repealed law, it doesn't mean that he's saying that the repealed law has repealed the offense, the alleged offense. No, a repealed law does not repeal a vested offense. That is why we do have savings or saving clauses in the law that repealed the old law. So section 97 and 98, particularly 98 of the Terrorism Prevention and Prohibition Act 2022, repealed the Terrorism Prevention Amendment Act 2023. But it saved proceedings, liabilities, penalties, and before that law was repealed. When Nigeria migrated from the Armed Robbery and Firearms Decree that was enacted by the military, and which was known for doing summary trial of armed robbers and subjecting them to firing squad, either in their village or at the bar beach in Lagos. We didn't continue to operate under that old law after 1999 when the army left. We went back to the normal penal code or the criminal code that prosecuted armed robbers and never subjected them to firing squad anymore. Rather, if the occasion warranted, they will be put to death either by hanging or such. So that's the migration we do. And then we have the Criminal Procedure Code, which was repealed by the Administration of Criminal Justice Act in 2015. So from 2015, all cases undergoing or ongoing under the old code, the Criminal Procedure Code, migrated seamlessly to the Administration of Criminal Justice Act. So Nnamdi Kanu wasn't saying that the repeal repealed my offense, because I saw some people, even some lawyers, making fun of that and taking issues with him. No, they are wrong. He's saying that his case should have been migrated into the current law. Unfortunately for him, the current law carries less stringent consequences for the offenses alleged against him. And you could hear the judge that they say, I should have imposed death penalty on you. Death penalty was required under the old law. The new law didn't require death penalty for the offenses he was convicted. So the judge was saying it was an act of mercy to impose life imprisonment on him. No, that is wrong, in my opinion. It wasn't. It comports. The new law has less stringent penalties. So the sentencing, at least, if the error was made in trying the case under the old law, or the judge felt justified in doing so under some authority of the Supreme Court or authority of statute, at least the sentencing requires that you migrate to the provisions of the new law, just like I have exemplified with armed robbers and the 1979 Constitution and the Criminal Procedure Code. So we repeal laws every day, and we don't keep doing things under those repealed laws. We do these things today under the current law. That was Nnamdi Kanu's thesis, and I stand by him.
Why do you think the court and the judge were probably not ready to look at migrate his case to the new law, and we are still fixated on the old law?
Well, the prosecution also was insisting on proceeding under the old law. I believe maybe the prosecution felt that it had some advantages. But you see, like I said before, nobody is infallible, including the judiciary. So the judge might have been misled. I am not attributing any mischief on his part. But nobody knows everything. You don't have knowledge of everything. Even judges who are supposed to be experts in the law may be misled. And that is why we have the Court of Appeal. And that is why I believe this is one of the major issues that shall be ventilated before the Court of Appeal.
So far, any progress? How far have you people gone? You have 90 days to make that appeal.
Well, at the beginning, you introduced me as Nnamdi Kanu advisor. Yes, I'm his advisor. I have also formed some friendship with him. I also see him as a brother, so I have a fraternal bond with him. But I'm not his counsel of record. I'm not his lawyer for now, and he doesn't have any lawyer for now. So how can he file an appeal before the Court of Appeal in Abuja that has exclusive jurisdiction over this case? How can he prosecute this appeal from 700 kilometers away in Sokoto himself? For now, Nnamdi Kanu is convinced that he does not need a lawyer, and it is his constitutional right under Section 36 of the Constitution to feel that way. So if he says, I want to file my appeal myself, or at least initiate the appeal myself and look for a lawyer later, it is his right. So the state is supposed to accord him the opportunity to exercise that right, because that right is protected by the Constitution of Nigeria and is guaranteed. It's given to him as inviolable. It's fundamental. So taking him to Sokoto defeats that right. So I do believe that is why he brought a motion before the Federal High Court to ameliorate the situation, to issue an ameliorative order that could transfer him from Sokoto prison to a prison in the vicinity of Abuja that will put him within a fighting chance of initiating his appeal before the Court of Appeal here. I think that is something that is worthy of consideration.
But looking at the way things are now, not having a lawyer, has 90 days to push appeal 700 kilometers away from Abuja, where the Court of Appeal should do that. What are the implications? Looking at it critically, what are the implications both for him, both for the government? Can we say he's been given a fair deal in the light of...
No, he's not being given a fair deal, at least as of now. But he has 90 days to appeal from November 28th, which will expire between the 17th and the 19th of February, I think, because they count it by the day. So for now, he's not getting a fair shake from the system. And the sooner he gets that fair shake, the better. You cannot, by the dint of insisting in keeping him in Sokoto, for which you have not given any compelling reason. Sokoto is not more secure than any other state in the country. It's prone to Boko Haram and bandit attacks. There's no compelling reason offered by the government for taking him to Sokoto, except giving this impression that, they wanted to yank him away from an area where he has a social safety net. I'm talking to you from Abuja here, so if Nnamdi Kanu was here, I probably would visit him every day, and some of my colleagues, all of them are here in Abuja as well. His family members are here. His physicians, personal physicians, are here. So his social safety net is here in Abuja. So yanking him away from here defeats the Nelson Mandela Rule. A lot of people don't know there is something that is called the Nelson Mandela Rule on imprisonment of some people. And that rule requires that a convicted person be imprisoned in an area that will be as near as possible to his relatives, as near as possible to the source of his welfare, his family, his friends, his lawyers, and to any court before whom that very convict has a case or will potentially have a case. So that Nelson Mandela Rule has been breached in this very instance. And it kind of gets you thinking whether Nnamdi Kanu is being targeted unnecessarily and unfairly, or whether this comports with how our government of the day wants to do things.
Why is it that a lot of persons have thought that some of the issues these days you hear about political negotiations, we are going to, he's coming out pretty soon, and people are wondering, why was all these insinuations and probably political consideration were not adduced or brought before the trial went this far? Now he's convicted. That's when everybody is talking about there will be a political solution. We are discussing with the president. How do you feel when you hear things like this?
Well, if you're familiar with my Twitter handle, I remember, you can recall around May, I believe this year, I made a tweet of a video done by Chief Raf Uwazwike. He had said almost the same thing, and he was calling on Ndibo to oppose the prosecution, that it was going one direction, that it was going to go to one direction. And I tweeted that video on my handle, and I got into trouble with the judge. The judge called me up in open court and, reprimanded me for posting the video. But that video reflected my personal fears, my inner fears as to the direction the trial was going, not actually the prosecution. My thing was about the prosecution, not about the trial, because I know about the rules of sub judice. So I wasn't directing anything against the judge. The judge was just there. They brought the case to him. He did not initiate the case. So every effort I made to prevent what happened, even when I was lead counsel, was geared towards stopping or halting the prosecution, including my media engagements. And I believe a few Igbos did likewise. I cannot deny that. I have to be here to acknowledge that Igbo actually tried. Our leaders tried. Some of the governors issued public statements calling for his release. A lot of political leaders from Igbo land did the same, and even from outside Igbo land. So that people are Igbos or Igbo leaders are calling for his pardon now is only consistent with what they had done before. They had always exhibited this groundswell of support and fraternity with Nnamdi Kanu, which is very admirable. It showed some unity. But there is a certain reluctance or, on the part of the federal government that demonstrates something we don't know. But if you want to know really what was leading to that reluctance, you have to go back to 2021. Someone said that they spent up to $10 million to rendition Nnamdi Kanu. So to me, that demonstrates a high government national security interest in the matter that is not being made known to the public. But why should that high national security interest be there? Why should it be more directed against Nnamdi Kanu and less directed against the bandits and the terrorists up in northern Nigeria? These are questions that rock the conscience of people and should shock the conscience of humanity. The aggression, the prosecutorial aggression towards Nnamdi Kanu is very unprecedented. And I think it overwhelmed an entire race of Igbo people at home and in diaspora who made very spirited efforts, including I know about the Association of Igbo Military Veterans in the United States. I know about the Ambassadors for Self-Determination and the Rising Sun. These are very prominent Igbo diaspora groups. And the World Igbo Congress, they did try. They made public statements. They came to Nigeria. They came into the courtroom. They showed fraternity and solidarity. And from home here, there was also a groundswell, monumental support and fraternity being exhibited and muscular steps taken towards the executive branch. Abaribe and our senators visited Nnamdi Kanu in detention, and so did at least two governors, Soludo and Oti. They did. Do you understand? And our House of Rep, notably Honorable Obiagocha and Ikenga Wochinyere. These things are in the public domain, but the federal government did not budge. So that kind of leads you to believe that this one is a special case to them, and it wasn't supposed to be so. But that is how it is.
The other day, the brother was in court to represent him on this issue of allowing him come close. Like you said, so where he has the social safety net. Mm-hmm. Unfortunately, the courts did not accept that fact that the brother should represent him, and he's far away. They can't guarantee him coming anytime he wants.
Yeah.
Where does he leave us?
Well, they did, and they asked him to bring a lawyer, and he went to the legal aid and secured one. So the hearing was eventually held on the 8th of December, and the matter was adjourned to 27 January. It was an ex parte application seeking transfer or order of court directing the federal government to transfer Mazen Nnamdi Kanu from Sokoto to a prison in the vicinity of Abuja. But the judge, in his wisdom, ruled that the prosecution and the prison authorities should be put on notice, and then the matter will be heard on 27th January 2026. That is where it stands right now.